Good morning. Good morning. The hearing will come to order. I will make some brief opening remarks. The distinguished acting ranking member.
Acting would be good.
Acting ranking member will make some remarks. Distinguished chairman will make some remarks. Chairman Feinstein will make some remarks. And if anybody else wishes to make some remarks, I'd like to try to get opening remarks closed before the 10:30 vote begins. And then we'll come back and go to the witnesses. I thank everyone for being here. Winston Churchill said, "In wartime, truth is so precious that she should always be attended by a bodyguard of lies." The truth of our country's descent into torture is not precious, it is noxious, it is sordid. But it has also been attended by a bodyguard of lies. This hearing is designed to begin a process that will expose some of those lies, that will prepare us to struggle with that sordid truth, and that will examine the battlements of legal authority erected to defend that truth and its bodyguard of lies. The lies are legion. President Bush told us America does not torture, while authorizing conduct that America has prosecuted, both as crime and war crime, as torture. Vice President Cheney agreed in an interview that waterboarding was like a dunk in the water when it was used as a torture technique by tyrannical regimes from the Spanish Inquisition to Cambodia's killing fields. John Yoo told Esquire magazine that waterboarding was only done 3 times, when public reports now indicate that 2 detainees were waterboarded 83 and 183 times. About Khalid Sheikh Mohammed, reportedly waterboarded 183 times, a former CIA official had told ABC News, "KSM lasted the longest under waterboarding, about 1.5 minutes, but once he broke, it never had to be used again." That, too, was a lie. We were told that waterboarding was determined to be legal, but we're not told how badly the law was ignored, bastardized, and manipulated by the Department of Justice's Office of Legal Counsel. Nor were we told how furiously government and military lawyers rejected the defective OLC opinions, but were ignored. We were told we couldn't second-guess the brave CIA officers who did this. And now we hear that the program was led by private contractors with a profit motive and no real interrogation experience. Former CIA Director Hayden and former Attorney General Mukasey told a particularly meretricious lie, that the Army Field Manual restrains abuse by naive young soldiers, but isn't needed by the experienced experts at the CIA. The Army Field Manual is a code of honor, as reflected by General Petraeus' May 10, 2000 letter to the troops, which I ask unanimous consent to have admitted as an exhibit to this hearing, without objection. Moreover, military and FBI interrogators such as Matthew Alexander, Steve Kleinman, and Ali Soufan are the true professionals. We know now that the experienced interrogators referenced by Hayden and Mukasey had little to no experience. In fact, the CIA cobbled its program together from techniques used by the SIRI program, designed to prepare captured U.S. military personnel for interrogation by tyrant regimes who torture to generate propaganda. To the proud, experienced, and successful interrogators of the military and the FBI, I believe Judge Mukasey and General Hayden owe an apology. Finally, we were told that torturing detainees was justified by American lives saved as a result of actionable intelligence produced on the waterboard. That is far from clear. Nothing I have seen convinces me this was the case. FBI Director Mueller has said he is unaware of any evidence that waterboarding produced actionable information. The example of Zubaydah providing critical intelligence on Khalid Sheikh Mohammed and Jose Padilla, often given, is false, as the information was obtained before waterboarding was even authorized. And there's been no accounting of wild goose chases our national security personnel may have been sent on by false statements made by torture victims just to end the agony. No accounting of intelligence lost if other sources held back from dealing with us after our descent to what Vice President Cheney called the dark side. No accounting of the harm to our national standing or our international goodwill. No accounting of the benefit to our enemies' standing and goodwill, particularly as measured in militant recruitment or fundraising. And no accounting of the impact this program has on information sharing with foreign governments whose laws prohibit the type of treatment and detention policies the administration has enacted. I could relate other lies, a near avalanche of falsehood on the subject of torture and what we've been told about interrogation techniques, but I suffer a disability. I'm a legislator. Legislators have no authority to declassify. Our Senate procedure for declassification is so cumbersome that it has never been used. All of the declassifiers in government are executive branch officials, and the Bush administration knew this, so they spouted their rhetoric, again much of it outright false and much of it misleading. And though many of us in Congress knew it to be false, we could not reply. It is intensely frustrating. We've been told you shouldn't criminalize conduct by prosecuting it. You criminalize conduct by making it a crime under the law of the land at the time the crime was committed. Prosecution doesn't criminalize anything. Prosecution vindicates the law in place at the time based on the facts that are admissible as evidence. We've been told you shouldn't prosecute people who followed lawful orders or relied on proper legal authorities or in good faith offered their best legal advice. But those are the questions, aren't they? And not the answers. This is the first of what I hope will be a series of hearings looking into these questions. I hope we'll soon be provided the Department of Justice Office of Professional Responsibility report on its investigation of the Office of Legal Counsel and hold more thorough hearings in the wake of that. Let me conclude by saying what a very sad day it is for America and for the Department of Justice that there should be such a thing as an OPR investigation into the United States Department of Justice Office of Legal Counsel, and how loathsome it is what a few men did to bring this upon that office. I'd like to thank Chairman Leahy for allowing me to hold this hearing. No one has worked harder and cares more about this issue than he does. I also want to acknowledge the tireless work of Senator Feinstein, my chairman on the Intelligence Committee, who is leading its detailed investigation into the Bush administration's interrogation and detention program. I applaud her for her efforts to get to the bottom of this shameful period of our country's history. Today we will hear from a distinguished panel of witnesses who will help us shed light on this topic. I thank them for their appearance this morning. I remind them all about unauthorized disclosure of classified information. I want to make a particular note about our last witness, Ali Soufan. Mr. Soufan interviewed al-Qaeda terrorists and went undercover against al-Qaeda. Threats against him have been documented. We ask the press to respect the security procedures we have in place and avoid photographing his face. Senator Graham, any statement you would like to give?
Thank you, Mr. Chairman. Well, I really don't know what to say or how to begin other than the difference between the nobility of the law and a political stunt may be soon evident one way